Good afternoon, everyone, and welcome to our very first 2020 webinar. I'm happy it's with one of our presenters I always enjoy hearing from. I'll introduce Donald in just a moment. Looks like we have our full house, so thank you to the topic, Don for the topic. We're going to see it's a little more widespread than recent regulations. But I do want to go ahead and get started. So thank you again, everyone, for joining. We are recording today's video, or today's presentation. It is going to be a video, and it will be on our website in the Client Resources section. For those of you who have joined us before for one of Don's presentations, you know that he is very well versed in many topics. Donald C. Works III is a principal in the Orlando office of Jackson Lewis PC, and he has an emphasis on management as he practices employment law, which is a good thing for us who have companies. He does have a Bachelor of Science from Auburn University. And Don, I don't think I've ever mentioned it, but one of our payroll managers is a gung-ho Auburn fan. I always give him a hard time. But
well, there are a number of us out there.
I understand there's a number. And also, you have your Juris Doctorate from the University of Miami. For those of you who have joined us before for one of Don's presentations, you know that he is very well versed in many topics. Donald C. Works III is a principal in the Orlando office of Jackson Lewis PC, and he has an emphasis on management as he practices employment law, which is a good thing for us who have companies. He does have a Bachelor of Science from Auburn University. And Don, I don't think I've ever mentioned it, but one of our payroll managers is a gung-ho Auburn fan. I always give him a hard time. But
well, there are a number of us out there.
I understand there's a number. And also, you have your Juris Doctorate from the University of Miami. I've enjoyed your presence as a past president in SHRM for Greater Orlando, as well as my local chapter, the Human Resource Association of Broward County. And you do hold, Don does hold both the SHRM SEP and SPHR certifications. Those are kind of difficult tests to pass. Not a problem for Don, I'm sure. And his notoriety is recognized by his peers and clients in the best lawyers in America, Florida Super Lawyers, and in Chambers USA. So he does have a great reputation, and I think you're going to enjoy hearing what, maybe not what he has to say, but that he does share the information so that you have a better understanding. So without further ado, Don, I do want to welcome you and thank you for being here today.
Well, thank you very much for the kind introduction, Sandy. And good afternoon, everyone. Happy New Year. This is the first, as Sandy indicated, in a series of webinars that Alpha staff will present this year. Each year, I participate in a couple of those webinars where we do update you on recent employment regulations, laws that are being passed on the federal level in particular, and also sometimes some state law developments. As we all know, Washington seems to be a little bit preoccupied right now with other things. In some ways, that's good news for employers because less is happening on the employment front. But in any case, this is not one of those occasions where I have a lot of new laws or new regulations to report on. So what I thought I would do is focus on three areas where we're seeing a good bit of developments on the state level, and also a third area where we have recently gotten a regulation from the United States Department of Labor concerning the Fair Labor Standards Act. So over the next hour, we're going to talk about non-compete agreements, or what I will refer to as restrictive covenants. And then we're going to talk a little bit about pay equity, and then finally the new Fair Labor Standards Act salary basis rule. Hopefully each of these areas you'll find of interest. I think they are somewhat hot topics, and you'll have some takeaways from this that you can use in your business. So let's start by talking about restrictive covenant agreements. And I'm going to approach this from a sports analogy standpoint, and we'll start with, how do you protect your playbook? What is your company's playbook? Well, there are different ways of protecting what is the playbook. Non-compete agreements and restrictive covenants generally are methods for protecting that playbook. But we're finding that the economy is booming right now, and employers are fighting over employees. We are handling multiple lawsuits across the country involving restrictive covenant agreements. And what we're finding is that some of the courts are reluctant to enforce those agreements. And in addition, there are a number of states that are getting into the fray and are passing different types of legislation that are making it more difficult to enforce restrictive covenant agreements. So I thought we'd take a closer look at non-compete agreements and talk about what you as employers can do to help ensure enforceability, given the fact that these types of agreements are really under assault at this time. We're going to first start out with an overview of the law of restrictive covenants. Then I'll talk about some non-compete developments and also no-poach agreement developments. And then finally, I'll give you some recommendations, some takeaways that you can use back at the office. So let's talk about our pregame warm-up. What's at stake? What's at stake for your business is, if you have a bad non-compete or a bad restrictive covenant agreement, one that's poorly drafted, you can ultimately lose your key players, customers, proprietary information, your trade secrets, marketing plans, and business strategies. So there is a lot at stake in this game that we're about ready to play. How can we protect the team going into the game? On the next slide, you'll see there are a variety of different types of agreements that employers use to protect the team, to protect what is at stake for your business. We start off with non-competition agreements, which you all know basically say that when you leave the company or during the time you're employed, you can't work for a competitor. We also sometimes use non-solicitation agreements, which prohibit employees or former employees from soliciting your employees or from soliciting your customers or clients. In addition, we use non-disclosure or confidentiality agreements to protect your confidential information. And then sometimes employers have severance agreements in which they include restrictive covenants. And before moving ahead, I want to talk a little bit about that last form of agreement, the severance agreement with restrictive covenants. In many states, Florida among them where I practice, the state law that permits you to have a non-compete agreement does so in the context of an employee-employer relationship. So while there's no case law on this point right now, one has to wonder if you are severing a relationship with an employee using a severance agreement, does an employer-employee relationship exist in which you could have a permissible non-compete agreement? Because of that doubt, we usually advise that you get these types of restrictive covenants on the front end and not the back end in a severance agreement, because enforceability is less likely when it's contained in a severance agreement, particularly with regard to non-compete, non-solicitation provisions. So these are the types of agreements that are available to protect your team and to protect what's important to your business. Now, remember, to be enforceable, restrictive covenants generally have to be supported by consideration. In some states, that could be initial employment. Other states allow it to be initial employment or just continued employment. Some states actually require that you pay a monetary amount to support a restrictive covenant. So you have to actually pay some money in addition to what you're paying the employee to work there for the non-compete, non-solicitation, or confidentiality clause to be valid. To be enforceable, the restrictive covenants also have to be shown necessary to protect legitimate business interest. And they have to be reasonable in terms of the length of time, geographic scope that's covered, and the scope of the activity that's restrained. Many states have specific requirements that limit the duration of a non-compete agreement. For example, Florida says that anything 6 months or less is presumed reasonable. Anything over 2 years is presumed unreasonable. Other states have developed law that says anything over a year is impermissible or unreasonable. The geographic scope needs to be tailored to the area in which the particular employee worked. And then finally, the scope of activity that's restrained should be limited to the type of activity that the employee actually engaged in when he or she was employed by the company. So these are the different factors that you have to consider in order to ensure that the restrictive covenants are going to be enforceable. Other questions that you need to ask yourself are, how do you treat your confidential information? Is it something that you're not treating as confidential, but sharing with anybody and everybody and making it, in essence, public information? If that's the case, you're not going to be able to protect it through an agreement. If you're considering suing an employee for breaching one of these agreements, what are the specific circumstances? What's the evidence that you have? Is it just hearsay that somebody's left and gone to another company and that they're contacting your customers? Or do you have specific proof? Another factor is, when and where do you seek enforcement? I mean, if you wait too long, then you weaken your argument that you need to protect legitimate business interests. And if you select the wrong forum, you may get a judge or state law that will find that the agreement you're seeking to enforce is unenforceable. And then on a local level, you need to consider what judge ultimately is assigned the case, because there is great variation among judges and their approach to these cases. Other considerations you can see in the next slide to consider in connection with preparing restrictive covenant agreements and also enforcing them are the state law nuances that we see. For example, in California and North Dakota, you cannot enforce a non-compete agreement with an employee. They are permissible in a buy-sell agreement where you're purchasing a business, but they're not enforceable in an employment agreement. Massachusetts, on the other hand, will allow you to have a non-compete, but there are very specific requirements that have to be met for enforceability. In Illinois, you can have non-compete agreements, but unless the employee remains employed with you for at least 2 years, the agreement won't be enforceable. Louisiana makes you list the specific parishes in which the person worked in order to enforce the agreement. Oklahoma won't allow you to have non-competes. And finally, Wisconsin will not allow judges to, quote, blue pencil an agreement. So you're probably wondering to yourself, what is blue penciling? So let's talk a little bit about that. Basically, the blue pencil doctrine allows a judge to either invalidate a non-compete outright due to it being overly broad, or to modify the overly broad provision to make it enforceable. So in some states, judges are allowed to blue pencil an agreement, that is, modify it and make it enforceable. Other states won't allow judges to do that. So the blue penciling we sometimes see would be, for example, if you had a 3-year non-compete, but the state only allowed 2 years, the judge might enforce the agreement, but only for a 2-year period of time. Or if your geographic area was overbroad, for example, if it referenced the entire state of Florida, and the judge found that it would only be appropriate to have enforceability where the person worked in Orange and Seminole counties, the judge could blue pencil the agreement. It's important that in your agreements you have language where the parties agree that the restrictions are reasonable and they intend for them to be enforced to the fullest extent possible. That language should go on to state that if the judge finds that an agreement provision is overbroad, that the parties desire the judge to modify the agreement so as to make it enforceable. So in essence, you encourage blue penciling. That said, the best offense is a good defense, and that's what we see in the next slide. Let's don't count on the judge to blue pencil an agreement. Don't forget what's at stake. I mean, your key players, your confidential information. What if the judge misses? What if he doesn't or she doesn't get it right? So we have to be very careful in drafting the agreements, and we can avoid pitfalls, as you can see in the next slide, by carefully drafting definitions as to what is your confidential information. I frankly have seen definitions of confidential information that go on for half a page, single space, and they mention anything and everything that might have to do with your business. Frankly, that's going to be overbroad. You need to think carefully about how you define A, the business that you're in, and B, what is your confidential information up front. Those definitions matter. They need to be very narrowly tailored to what it is that you're trying to protect. If you go overly broad, like the definitions that I've seen, and you're intentionally vague, thinking that you're going to cover everything, you risk the fact that a judge may find that the agreement is overbroad and not enforceable at all. So the key is careful drafting and very specific definitions in your agreements. So let's say you've got these agreements in place. You've done what you need to do to protect what's at stake. Looking at the next slide, you can see what's happening with legislation. So you've got the agreements in place. Are they going to be enforced? Well, beginning in 2016, President Obama issued a, quote, call to action to the states asking that they consider reforming non-compete laws to permit people to basically get out of them and be able to work wherever they want to work. I think the idea was well-meaning. We want people to have an opportunity to be employed, and perhaps at the time that was a bigger concern than it is right now. But in any case, that call to action spurred a lot of action by different states. For example, I referenced earlier Massachusetts law that has some very specific requirements in it for non-competes. That came about in 2018 after the call to action. Then we also have Utah and Idaho passing amendments to their legislation to make it more difficult to enforce agreements. Importantly, this year, there are legislatures across the country that continue to pursue non-compete reform to make it more difficult to enforce non-compete agreements. And you can see just a few of them listed there: New Jersey, New Hampshire, Pennsylvania, and Vermont. Keeping that in mind, if you are operating in multiple states, you need to be very careful to be aware of the variances between the laws in those different states, because a one-size-fits-all agreement will not work for you. Another development that we're seeing on the federal level has to do with no-poach agreements. Now, basically, no-poach agreements are agreements where you agree with another company that you won't hire their employees and they won't hire your employees. And there's some industries where this is pretty common. In 2018, the Department of Justice ended up bringing an antitrust action against the world's two largest rail equipment suppliers for having these types of what they refer to as naked no-poach agreements. And the DOJ has subsequently said that they intend to zealously enforce antitrust laws to end anti-competitive no-poach agreements that harm employees and the economy. On the state level, in the next slide, you'll see with respect to no-poach agreements, we are, and going back one slide actually, Sandy, what we're seeing on the state level is that attorneys general from 11 states and DC have begun taking action, in particular against fast food restaurant chains who use these no-poach agreements. And a number of those states you can see listed there: California, not surprisingly, New York, New Jersey, Washington, among those that are going after no-poach agreements. So that is something that's getting particular attention from the legislatures, that is no-poach agreements. So what can you do this coming year in 2020 to be sure that you protect what's important to your company? and to protect your team. First of all, you should take a look at your non-compete agreements. Make sure that they're narrowly tailored to protect your legitimate business interests. And make sure that they don't impose an undue hardship on the employee. If you think that you would be safe if somebody did not go to work for a competitor for 6 months, make it 6 months. Don't make it 2 years or 3 years. If you think, for example, that they really could not do any harm if they worked in a different county, then only restrict them for the county in which they previously worked. These little things that you can do in your non-compete agreements will make them much more enforceable. Similarly, if you have no poach agreements, make sure that they're not, quote, naked agreements where they're just outright prohibitions instead of a non-compete agreement that would prohibit an employee from working for a competitor. Other things to consider you can see in the next couple of slides. How should the geographic scope be drafted? Should we be using severance agreements, or do we want to get non-competes up front? What do we do if we have a merger or an acquisition? Do we need to get all new agreements, or do our prior agreements provide that a successor can enforce them? Also consider in the next slide, are your documents in order? What's your risk tolerance? Who are your starting five? Who are the key players that you want to ensure don't go to work for your competitor? All of these factors need to be considered. So during the next several months going into 2020, I would encourage you to take a look at your agreements to make sure they're enforceable. As I indicated, because the job market is so competitive right now, when employers are losing employees, they are going after them. And when you go after an employee under a non-compete agreement, you want to make sure it's enforceable. Another thing you should be careful about, given the fact that we are seeing a lot of litigation now, is asking prospective employees if they have non-compete agreements with their current employers. If they do, you need to take a look at them. And if they are enforceable, you may want to give some second thought to whether or not to hire that prospective employee. Doing so could embroil you in a lawsuit and cost the company a lot of money. All right, so that's where I'll leave it in terms of restricted covenant agreements. And we're going to shift gears now and look at another hot topic. You know, last year we had all the talk about the Me Too movement. In the last 6 months, I'd say the focus has really been on pay equity. Now, I'm going to share something with you all that I don't share with many people. And I started practice in labor and employment law over 30 years ago. Many times I have thought to myself, if I ever went to the dark side and I started representing employees, I would handle only equal pay cases. And I say that because I know that every employer has vulnerability in this area. Now, I don't plan on switching sides at any time in the future. I enjoy my career representing management. But I caution you all that this is an area where a lot of plaintiffs' lawyers are discovering there is a pot of gold at the end of the rainbow, and they're pursuing these types of claims. As you can see in the next slide, everybody's talking about pay. This is something that we're hearing from not only the news media, but also from shareholders of corporations, a lot of different folks. This is just a secret deodorant ad where somebody is talking about pay. We need not look at the video right now, but it's an example of how we're seeing it even in advertising, talk about unequal pay. Who's talking about pay? Well, really everybody. The next slide, you'll see all the major corporations that are dealing with pay equity issues. So if you're dealing with them, you're in good company. And what is it that they're talking about? We need to be specific when we use definitions in this area. You can see in the next slide, there are really two different discussions going on. One discussion is the discussion of pay gap, that is, pay differences in gender and race groups among all jobs. So just for example, saying that women generally make less than men, or African Americans make less than whites. That is a pay gap. On the other hand, when we talk about pay equity, we're talking about equitable pay for people who are in similar positions. So when you do a pay gap study, it's going to be a lot different than a pay equity study within your organization. You can see in the next slide, and the data is somewhat, that's available right now, is somewhat outdated. This is from 2014, so it goes back quite a ways. But you can see that this is a reflection of gender pay gap. So this would include the year-round female earnings as a percentage of male earnings in all jobs, not specific to a particular job. So you can see there's some states where the percentage is 73%, very low, 71% up in North Dakota, 73% in Idaho. On the other hand, you have states where the pay gap is not as great. For DC, it's only about 90%. In Florida, 85% at the time. But there's one thing clear from this chart, and that is there is a significant gender pay gap when you look at all jobs. If you take a look at the next slide where it's pay gap by industry, you can see broken down by industry what the gap is between men and women and their pay. The green numbers reflect overall what is the pay gap overall, all jobs. Whereas if you narrow it down to specific jobs, you can see that the pay gap is significantly less, but nevertheless, there still is a pay gap between men and women, even when you narrow it down to particular jobs. So what's driving us to focus on these pay gaps or pay inequity? Well, as we saw in business law today, this is a quote, "Never underestimate the power of shareholder engagement." And we're seeing reported in a lot of the different business channels, shareholder groups, activist investors who are putting pressure on companies to achieve pay parity and transparency. You can see in the next slide that the CEOs and boards of directors of various companies are telling HR and in-house counsel that this is going to get done. So we're seeing large corporations nationally starting to do pay parity analyses and pay equity analyses to determine whether or not they have pay parity in their company and pay equity within their company. So you've got shareholders putting pressures on you. And then in addition, we've got state and local governments, as you can see in the next slide, putting pressure on corporations to take action in this area. Speaking about pay equity, a couple of years ago, New York Governor Andrew Cuomo stated, quote, "At these stormy times of instability and confusion, let New York serve as a safe harbor for the progressive principles and social justice that made America," encouraging New York employers to take a closer look at pay equity within their corporations. So some of the state law themes that we're seeing when they're developing legislation to ensure pay equity, you can see in the next slide, they're expanding definitions of which employees are considered comparable. In other words, what positions are comparable positions. They're limiting the reasons that can be used to explain pay differences. They're expanding recoverable damages, protecting employees against retaliation. They're restricting access, and this is very important, to prior salary history by limiting an employer's ability to ask about prior salary during the interview process. And there are states that are encouraging self-analysis through their legislation. In the next slide, so we've got state and local governments pressuring you, we've got shareholders pressuring you, and then when they pressure you, they point to other corporations and other countries, in fact, who do not have the gender pay gap that we do here in the United States. And you can see in the slide some of the more recent data showing the countries that have greater pay gap than others. And the United States falls pretty much right in the middle. But some countries are far ahead of us in achieving pay equity. And that is something that state and local governments point to. Many countries, as you can see in the next slide, have specific equal pay regulation, as does the United States. We have the Equal Pay Act that's been in effect for many, many years. So how are you going to respond? Well, the next slide you can see one approach that you could take, the ostrich defense. Just stick your head in the sand and pretend it doesn't exist. But seriously, what questions are you going to ask yourself? Some of the things that you need to ask and try to answer are, for example, how are females paid as compared against males across the organizations? That's like a pay gap analysis. It's not job per job, it's just generally females against males. How are minorities paid against non-minorities? Again, it's a pay gap analysis. But then drilling down further, where might we have risk under Title VII or the Equal Pay Act? What pay groupings have unexplained disparities? Which individuals are driving the pay differences? And which individuals are below predicted pay or what their pay should be based upon their job? And then consider generally what factors are influencing pay in your organization. And finally, who should be considered for a pay adjustment to eliminate any type of pay disparity. In the next slide, you can see different steps that you can take, developing pay groups that mirror your pay systems, and then evaluating whether broader groups should be reviewed. Using statistical analyses, we work with employers doing regression analysis to determine whether or not there's actionable pay disparity. And finally, evaluating pay groups with red flags where there are apparent differences. What's causing the pay disparity? And evaluating, do you have any defenses? Are there good reasons for that? Some defenses that might be available to you, you can see in the next slide. Some general things that employers point to explain pay differences would be a seniority system, a merit increase system, some system that measures quantitatively, not quantitatively or subjectively, the quantity or quality of production, the geographic location. For example, people often get paid more in the Northeast than they do in the Southeast. Work performed on different shifts. Travel is greater. All these are different defenses that might explain pay differences. Under the Equal Pay Act, what you are supposed to ensure is that jobs that require equal skill, effort, and responsibility and are performed under similar working conditions at the same location should be paid equally. So you should be looking at the skill, effort, and responsibility required in a particular job. And if all else is equal, the individuals should be paid equal. So let's take a quick look at an example here of a pay analysis. We've got Bob and Mary. They're both senior financial analysts in the Denver, Colorado office of the company. Bob's making $95,000 a year. Mary's making only $75,000 a year. Is there equal pay? No. Is there fair pay? Well, let's find out. And how do we do that? We do that by doing a regression analysis on everybody in the senior financial analyst group, which has a total of 35 employees. So one of the things we'll look at in doing that analysis is the performance of the individuals in the position. And in the next slide, you can see that Bob was rated as an outstanding performer in 2018, and Mary was rated as an average performer in 2018. So that would explain roughly $4,000 in the difference or the pay gap, and leaving $16,000 unexplained. Now that says 30% of pay variations explained, but it's actually more like 20% is actually explained by performance. What other factors might we look at? Is there a difference in their education? In the next slide, you can see that Bob has a master's degree, whereas Mary only has a bachelor's degree. So maybe 6,000 of the pay difference can be explained by education. And then finally, let's factor in prior experience. Bob has 10 years experience in the position, whereas Mary has none. That would account for the other $10,000 in the pay difference, leaving an unexplained difference of $0 and an insignificant pay disparity. In other words, one that does not need to be addressed. So this is just a general example of how we would analyze a position, including and considering different factors that are legitimate defenses to an equal pay claim, using regression analysis to determine whether any action is necessary. So let's say that you find that there are differences in pay, significant differences. And it's kind of interesting when you do these studies. I'll mention that I've worked with a number of companies on them, but in particular, I had one company where they did a study and they were suspecting that there was a big pay gap based on gender. In fact, they thought women were making much less than men. As it turns out, in some locations, men were making much less than women. So how you proceed is going to be dictated by the findings of your study. One of the things that shareholders are pressuring companies to do, and that is to go public, that you ought to be disclosing, or they're considering that you ought to disclose whether there are issues and what you're doing about it. And many companies are trying to take this issue and put a positive spin on it, that we have analyzed all of our pay data and we've determined that people are behind and we're bringing them up, and aren't we a great corporation, and trying to spin it that way to get positive marketing out of it. Some of the issues that you need to consider are, who are you going to publish to? Is it going to be just your employees when you make the adjustments, your shareholders, or are you going to go public with it? If you do disclose the study you do, you're risking waiving attorney-client privilege as to the study if it's done by counsel. And then if you disclose this year, are people going to expect to hear from you next year and years after? So these are all factors that you need to consider, and really consider before you do the study. How are you going to handle it depending on what the findings might be? So what are the key takeaways in this area of pay equity? First of all, you need to identify what are the questions that you're being asked to answer. Are we talking about a pay gap or pay equity? What is the concern? And then consider conducting privileged pay equity analyses, having them done by your legal counsel so that there is protection of the findings should you decide not to take action. Finally, consider conducting a pay gap analysis, and consider if you want to make any public disclosures. So I challenge you all, when you hear about pay equity, and you will hear about it, or when one of those plaintiff's lawyers gets a hold of you on an Equal Pay Act claim, and there are more and more of them, you need to be prepared. And to be prepared, you need to think about these questions, start doing the studies, and make appropriate adjustments. All right. Finally, the last thing I'd like to talk about today is the new FLSA salary basis rule. Some of you, I'm sure, have heard about this new rule. It's been in the news for many, many years and finally became effective January 1 of this year. So starting with the FLSA, what we're referring to is the Fair Labor Standards Act. And just as an overview, you can see in the next slide, the law requires the payment of minimum wage and overtime. And the goals of the law, it was passed back during the Depression in the 30s, were to reduce unemployment by, in essence, requiring employers to hire more people rather than pay the penalty of overtime. The idea was that we would also, through minimum wage, ensure a fair day's pay for a fair day's work. So these requirements, the minimum wage and overtime requirements, are subject to a number of different exemptions. And the primary exemptions that exist under the law, and there's 20 some odd exemptions, anything from holly wreath manufacturing to sponge farming, summer day camps, et cetera. But the primary exemptions are what they call the white collar exemptions. They're for executive, administrative, professional, and outside sales employees And within the professional exemption, there's also computer professionals. In order for somebody to qualify for the white-collar exemptions, they have to pass specific tests. They have to be paid a predetermined and fixed salary. That's the salary basis test. The salary has to be at the minimum level specified in the regulations. And then finally, their duties have to fall within the duties defined for executive, administrative, or professional employees. So these are the key exemptions that we're looking at. And the regulation that I want to talk about in particular is the one that deals with the salary level that is required in order to meet the salary basis test. So how did we get to this rule? Well, back in 2016, the Department of Labor Wage Hour Division published a proposed rule where the standard salary level would have increased to $47,476. That would be more than double what the salary requirement was at the time. At the end of that year, a federal district court issued an injunction blocking the rule from becoming effective. In 2017, the Department of Labor, now under the Trump administration, requested information seeking input from the public on this new rule. And then ultimately, last year, the DOL issued a notice of proposed rulemaking setting a new salary standard. And last year, they announced the new final rule. So what is the new final rule? Well, what the rule does is it increases the minimum salary level for exempt employees, and you can see in the next slide, from $23,660 a year to $35,568 per year. So that's an increase from $455 a week up to $684 per week. Pretty significant increase, but not as large as the increase that had been proposed back in 2016. The other thing that the DOL did in these rules, you can see in the next slide, is they increased the salary for somebody to be considered a highly compensated employee from $100,000 annually to $107,432 annually. Now let me stop for a moment and clarify. In the exemptions, there is a special exemption for highly compensated employees. And basically what it says is if you pay somebody $107,432 a year, and they perform one or more of the duties of an exempt executive, administrative, or professional employee, then we're going to automatically consider them to be exempt from the requirements of the FLSA. So there is this highly compensated employee exemption, but it is a much higher salary level, as you can see. So what was the rationale for these increases? You can see in the next slide, they say that they wanted to better define the white-collar exemptions for executives, administrative, and professional employees while reflecting current earnings that had been in place since 2004. So they wanted to better define things but not have too great of an increase. Another change that they made through the rules, you can see in the next slide, is that they have now said that in order to meet that minimum salary of $35,568, you can use incentive compensation in the form of commissions, non-discretionary bonuses, and other incentive payments to make up 10% of that salary. And there's actually a provision in the law, you can see in the next slide, where that 10% can be caught up on an annual basis, whereas under the prior Obama rule, you would have had to do catch-up payments quarterly. Significantly, that 10% rule where you can use incentive compensation to make up part of the salary, that does not apply to highly compensated employees. They have to meet the full standard salary level of $107,432 to qualify for that specific exemption. Another thing we learned through the rule making, in the next slide you can see, is that there are no automatic increases in the salary level. Under the prior rules that were published under the Obama administration, there was going to be automatic increases every 3 years. Basically, what the DOL has said now is that they'll look at salary levels on a regular basis and at least every 4 years, but there are not going to be any automatic increases in the minimum salary. As I said earlier, and as you can see in the next slide, the new rule became effective January 1 of this year. And of note, there's been no change in the duties test. So the test that you have to pass showing that the person performs the duties of an executive, administrative, or professional employee, those tests remain exactly the same. They haven't changed. The only thing that's changed is the salary basis. Other things to note, first of all, the rule does not change the outside sales exemption or the professional exemption as it relates to teachers, doctors, or lawyers. Those exemptions don't have a salary requirement. So this new salary requirement only applies to executives, administrative employees, and other professionals, that is, professionals other than teachers, doctors, and lawyers. It does not apply to outside sales or teachers, doctors, and lawyers. In addition, non-exempt employees don't have to be paid hourly. They can still be paid salary, and the salary doesn't have to meet the minimum. The minimum is only a minimum for the exemption to be in place. So the only thing a non-exempt employee has to be paid is minimum wage, and you can do that through an hourly rate or salary. Just make sure they get minimum wage and at least time and a half minimum wage for hours over 40. Finally, on this slide, I'll note that the new salary level does not apply to employers in Puerto Rico, the Virgin Islands, Guam, or the Mariana Islands. The current salary level, $455 a week, continues to apply, and it's as low as $380 a week in American Samoa. So hopefully you've already dealt with this issue, but if you have not, some strategies that you can employ, some different options. One option is just increase the salary level for your affected exempt employees and make sure they maintain their exempt status. Option two, you can see in the next slide, would be go ahead and reclassify exempt employees who don't meet the salary level, start paying them overtime. Option 2.1 would be to reclassify them as non-exempt and back into an hourly rate, which would anticipate overtime so that the reclassification is cost neutral. Option 2.2 would be to reclassify and use the fluctuating work week method of pay where it's allowed by state law. That would be a situation where you have to have a written understanding in place with the employee that their salary is being paid for all hours worked in a work week, in which case they would only get half time for overtime. So that's option 2.2. The next slide shows two remaining options. One is just reduce the hours to avoid overtime and shift the work to other people so you don't have exposure regardless of whether they're exempt or non-exempt. And then finally would be hire more part-time workers so you avoid any possible overtime. So this is a little bit of a challenge, but as you can see in the next slide, with each challenge comes an opportunity. So it's an excellent time to conduct a wage and hour audit, reviewing the duties requirements and also the new salary requirement to determine if your exempt employees truly qualify for the white-collar exemptions under the Fair Labor Standards Act. So that concludes our discussion of the FLSA and our discussion of the three issues I wanted to bring to your attention today. I hope you have learned something, and if there are any questions, I'll be happy to try to answer them now.
Great, thanks, Don. And we do have a question. Actually, we have a couple of questions.
Okay.
The first is, do you believe the new contractor laws in California are indicative of the direction that federal laws will move towards or other states will adopt?
I believe the reference is to the laws that are making it much more difficult to classify workers as independent contractors. We've seen that in California recently, and yes, I do think that that's indicative of what we're going to see in other states. If I'm off base in what I understood the question to be, please let me know. I'll be happy to try to address it more specifically, but I think from what I can tell, you're identifying an issue that is a hot issue, and that is cracking down on independent contractor use by employers.
Right, that's how I read that as well. So thank you.
Mm-hmm.
And certainly, Paul, if that was not your intention, please go ahead and just type into the Q&A again. Also, Don, is it a fact that outside sales do not have to meet the salary level?
That's correct. There is no salary basis requirement for outside sales.
Okay, great. And Paul confirmed, yep, that's exactly the question.
Okay.
All righty. Somebody's asking about getting a copy of the slides, and yes, we do provide that as well. When you request it, I'll show you in a moment how to do that. And actually, that's the last question.
Okay.
So I'm going to go ahead and move on, Dawn. If somebody does type in another question, I'll bring it up, but I do want to thank you again. And my computer's giving me grief. Here we go. So as I promised, if you, well, actually right here, if you wanted to get the presentation, our HR Service Center will take those requests, or your HR account manager can also track that down for you. If you are looking for the SHRM and the HRCI credit information, that's also available through the HR Service Center and your HR account manager. So please don't hesitate to contact either one. I do want to invite everybody to our next webinar, which is February 20th, 2020 at 2 p.m. I'm a numbers person and I just love it's 2/20/2020 at 2. You can't miss it. It's got to be good, right? It really does provide some wonderful information for you. The health advocate is something that you may or may not have through our benefits, but it's for your entire household, and typically the health advocate falls under our employee assistance program. The two are a little bit, they have unique characteristics, but it's a good conversation to listen to so that you can learn, is there anything there, not just for your employees, but for you or anybody in your household. So mark your calendars on that. Susan Hunt, who's an account executive with Health Advocate, will be leading that conversation. So I see no more questions, so I will go ahead and close. Don, again, thank you. And everybody, I hope this
My
is—
pleasure. Really, thank you.
You're welcome. Thank you. I hope this is everybody's very best year. Let's hope, right? So take care.
Thanks, Sandy. Bye-bye.
You're welcome. Bye-bye.